How should attorneys advise their clients who are new to a public company board? I'm Jack Clabby, the law firm of Carlton Fields. That's what we're going to discuss on today's American Bar Association Sound Advice podcast. I'm an attorney in Tampa, Florida. I lead the Securities Litigation and Enforcement Practice Group at Carlton Fields. I'm also active in the ABA. I co-chair the Class Action Subcommittee of the Securities Committee within the section of litigation. Joining us today on our 5 tips for a new public company board member is my partner, Brian Soares. Brian is a business transactions shareholder here at Carlton Fields. He works with private and company public boards all the time. Before he joined us at Carlton Fields, he was special counsel at the SEC's Division of Corporation Finance at the Office of Mergers and Acquisition. All right, Brian, we're going to go through our top 10 tips here for someone who's sitting on a public company board. The idea here is that this can help the members of the ABA who are called to advise these new public company board directors. So let's give them we'll give them our top 5. Why don't you go first, Brian?
Sounds good. And thanks for having me, Jack. So, first off, I think it's important for us to talk a little bit about public company filings. What are they and what is the board's role? I think usually that's one of the first things that I end up advising clients when they join a public company's board, or if they've had somebody who's never served on a public company board before joining one of our clients. That is one of the things that we'll cover with them. So, public companies in the United States listed on the New York Stock Exchange, NASDAQ stock market, or other national securities exchanges are required to file a number of reports with the Securities and Exchange Commission. These include annual reports on Form 10-K, quarterly reports on Form 10-Q, and other periodic reports. They're also required to file their proxy statements in connection with their annual meetings of stockholders. This is an opportunity for public companies to tell their story. A lot of folks treat this as a burden because they're required to under the rules of the SEC. But really, folks should treat this as an opportunity, and not just directors, but any person at a public company involved with these disclosure documents should really treat this as an opportunity to tell their narrative, the company's story. So the board's role when it comes to disclosure is one of oversight. Members of the board are expected to review certain of these disclosures, especially the big ones, the annual report on Form 10-K, the quarterlies on 10-Q, and the proxy statement. And they should feel free to comment and ask questions as part of their review. Indeed, that's one of their roles as gatekeepers. So in reviewing these draft filings before they're filed, directors should think of issues identified over the course of exercising their duties as they review the draft disclosure. Have they identified any potential red flags? Why or why not is a particular issue being disclosed or being left out of the filing, right? These are the types of questions that they should be asking folks in the legal department, and they should feel comfortable doing so. Another important aspect is familiarity with the corporate processes used to prepare the filings. This is, I'd say, just as important as the disclosure within the 4 corners of the document. Directors should be familiar with what stakeholders within the organization are involved in the filing, in the drafting process. How is information being filtered up from rank and file up to other folks and directors and managers making into the disclosure document? They should be familiar with that and make sure that they're comfortable with that process and consistently and constantly reviewing and analyzing that process to make sure that the right information is making its way into these SEC filings. To be best equipped to oversee this disclosure process, directors should understand a company's business model and its associated risks. They should understand the company's financial condition, its industry, and its competitors. Presumably, these directors have been selected to be nominated to serve on the board because they already have a good amount of familiarity with these items. But of course, there's always some getting up to speed that is required once they actually join the board. And then lastly, because we're lawyers, right, we're constantly thinking of potential liability. So I'll mention that directors can be exposed to civil liability for certain untrue statements of material fact or omissions of material fact made in periodic reports or registration statements filed with the SEC. And indeed, directors are required to sign the company's annual report on Form 10K and the company's registration statements filed with the SEC when the company is making an offering of securities. So directors need to consider not just the importance of the disclosure in general to make sure they're telling the company's story properly and effectively, but also because there can be potential civil liability there, depending on certain untrue statements of material fact or omissions that might be made in these filings.
I like that, Brad. I like starting the list of 5 tips with the sort of public filings with the SEC, because that's the main difference in terms of the experience of a director serving on a private company board versus a public company board. Is a public company, because its shares are available publicly, has those obligations that come from being registered with the SEC, and those obligations about speaking to the market generally, which is not something in general terms that a private company director has to deal with. Our second tip has to do with appreciating, as a new director, the duty of care. So its evil twin sometimes gets more attention than the duty of care does. That's the fiduciary duty of loyalty. Fiduciary duty of loyalty often leads to liability, which are things like, did a board handle self-dealing among its directors adequately? Did they disclose conflicts before an M&A transaction? Are the directors looking out first for the company, or are they looking out first for themselves? But on a day-to-day basis, right, for a lawyer who's advising a new public company director, it's likely not going to be the fiduciary duty of loyalty that's going to command the room. It's this duty of care, which is the more basic duty, the one that's less likely to lead to liability. That said, misunderstandings around the duty of care can lead to litigation, even if the relatively low standard to meet means that there's not going to be a finding of liability. And how does this show up, right? So if we're working with a client who's relatively new to a public company board, who has found themselves, in their view, named in a complaint in a private company litigation, right? They're going to say something like, Jack, why am I being sued? Why am I named in the complaint? I wasn't involved. I barely attended the board meetings. I didn't ask questions. So that, again, if that's the true fact pattern, it doesn't mean they're going to be held liable for a misstatement in the public company financials. It's probably going to be that they're going to have a defense and get out of it. That said, it's not a defense to say you didn't pay attention, right? So what is this duty of care, right? It's paying attention. It's, before a board meeting, the corporate secretary, the deputy general counsel will send out to the directors, potentially through email, potentially through a board portal, information that they're going to then discuss and present on through management at the meetings. Read those things. It's that easy, right? You get information in advance of the meeting, start with the agenda, read it, start with the proposed resolutions, if any, read them. And if there's supporting materials, at least look through them so you know if you have questions on them, and you can come sort of prepared to hear management's presentation and to make decisions. Show up and ask questions. So it's not enough to sit there and receive the briefings. If you have questions or you don't understand, ask them. And lastly, follow the industry, right? So if you're working in the hospitality industry, or you're sitting on a board that's in the hospitality industry, pay attention to what's going on, even if you're there for some other skill set. Let's say you're on the audit committee and you're a former or a current auditor for public companies, and that's why you're there, but it happens to be, a healthcare client, or it happens to be a hospitality client. Get to know that industry in particular. Maybe start reading some industry magazines or industry blogs to be up to speed generally on what's going on, right? That said, don't go too far. Remember that as a public company board member, you're not the manager, right? You're there for oversight, long-term strategy, hiring, and evaluating the CEO. You're not there to be a manager. This can be a problem for high-powered executives who transition over or transition into public company board seats, is they can't take that executive or that manager's hat off. When they sit as a board member, they're doing a very different role. It's the role of oversight. So I think that, Brian, to me, is the second tip, is have an awareness of this duty of oversight, this duty of care, and what it really means in practice.
I completely agree. And one point to highlight here, I really like what you said at the end about that you're not the executive, right? You're not the manager. You're overseeing. A recent PwC survey, and they do these annually, surveyed about 500 C-suite executives. And about 32% of these executives responded saying that they think their boards overstep the boundaries of their role. This was twice the percentage who said so last year, right? So that's a significant increase there. And indeed, it's a fine line to navigate between oversight, but not being another manager. So I think that's really important to be aware there. And I think the key, like you said, is to ask questions.
Absolutely.
So next tip, this one here is I'm going to drill down on the issue of executive compensation, even though we're talking about directors. But there's a broader lesson or a broader tip here, which is how to navigate new rules or the ever shifting SEC disclosure rules. So this week, in a couple of days, the SEC is hosting a roundtable to revisit its executive compensation disclosure rules. It's been almost 20 years since the bulk of these rules have been significantly revised, though, of course, there have been a number of additional disclosure requirements adopted over the last 15 years, mostly under Dodd-Frank, since it was enacted in 2010. Things like SAM pay, CEO pay ratio, pay versus performance. So I think we can expect some big changes in this space in the next year or so from the SEC under the new administration. The thing to hammer home here is that directors, again, back to that role of oversight, when it comes to new rules, directors need to be familiar with those new rules. They need to understand potential impact. And again, they need to ask questions, right? That's part of their oversight role in reviewing draft disclosure. Of course, compensation committee members highly involved here as they digest any new rules that come out of the SEC in the near or not too distant future. But even if you're not in the compensation committee, you should still feel comfortable to ask questions when it comes to executive compensation disclosure, as with any other area of disclosure, because this is a space that attracts a lot of attention. It's something that shareholder activists focus a lot. It's something that ISS and Glass Lewis, the two main proxy advisors, are hyper focused on. And so, whether you serve on the compensation committee or not, directors should feel comfortable to ask questions and really drill down in the disclosure as part of their review. So again, the tip here, not just with executive compensation, I'm using it as an example, but with any new SEC disclosure rule, any changes to SEC disclosures, reach out to the legal department in your company and ask them to explain the new rules to you, maybe do a presentation for the board on what these new rules mean, maybe bring in outside counsel to help out with that so that the board can get up to speed on these new rules.
That's really helpful, Brian, because that really is the crux of one of the core responsibilities of a public company director is going to be to not manage the CEO, but hire the CEO, evaluate the CEO, and deal with CEO pay issues, but also those highly ranked or highly compensated employee issues that are going to lead into disclosures, and they're going to lead to the need for the board to approve certain stock plans. The fourth of our 5 tips today for how to advise a new member to a public company board involve personal legal risk to sitting in that chair. There really is quite a difference in character between sitting on a private company and a public company board. On a public company board, there's exposure to regulatory investigations, shareholder investigations, and all other manner of potential litigation. And so we think about the sort of 3 core aspects of risk mitigation: insurance, indemnity, and liability limitations. So a new public company board member should ask for a copy of the insurance program and literally a copy of the insurance policy for the directors and officers insurance to know what it covers and what it doesn't. They should similarly look at or get copies of the bylaws and the articles to look at what it says about indemnity and advancement. And by advancement, they mean, will your legal fees be covered for any defense in real time, or do you have to wait to the end to get them reimbursed? But you'd want to look through what the articles and the bylaws say about mandatory versus permissive indemnification and mandatory versus permissive advancement. Is this to the extent of the law in the state where the company is incorporated, or is it subject to a later board vote and could be provided or withdrawn? And then finally, those same corporate documents or the law of the state of incorporation will lay out whether there's any liability limitations. A little different from indemnity, but basically it says that at no point, or only under the occurrence of certain events, will the director be liable for misconduct. And typically it's a fraud or a gross negligence standard. And it essentially removes the risk of liability for allegations that are below that level. But just having this understanding of the risk and then what mitigations are in place can really help. In addition to insurance, indemnity, and liability limitations, getting to know a little bit about the cash position of the company, reading their public financials before you actually accept the job as a public company director, wrap your arms around risk. Brian, you want to talk about our fifth one, which I think kind of stays on this line of good governance being a risk mitigator.
Sounds good. Indeed, governance is critical when it comes to public company life. So, as a new director, it's important to understand your company's public governance structure, whether as cumulative voting, classified board structure, et cetera. And to keep that in mind in the activist context. Just this proxy season that wrapped up, most companies have their annual meetings of stockholders in the spring, calendar year companies in particular. So the bulk of public companies in the US have had their annual meetings by now. So we have a lot of results from these companies' annual meetings. And we've seen that, again, consistent with the past, corporate governance has continued to play a big role in activist activities. And indeed, governance issues have driven the outcomes. So in this last proxy season, governance concerns flagged by ISS and Glass Lewis, again, the two main proxy advisory firms, had a significant impact on voting outcomes. In one instance this year, an activist won 2 seats on the board of an S&P 500 company. Turns out one of the big reasons was because ISS criticized that company's governance, citing specifically a classified board structure, supermajority voting thresholds, a combined CEO and chairman role, and entrenched legacy leadership on the board. So the lesson here is coming into a public company as a director, it's first of all, of course, familiarizing yourself with what the company governance structure is, but then assessing, does this expose us to potential activist activity? Again, especially when a company's entrenched, right? When you have directors that have been there for a really, really long time, they might not be as aware, or at least not willing to be as aware of those potential issues. So having a new voice pointing this out, especially somebody on the board and not, say, outside counsel or an outside advisor or an employee within the company, but somebody, a fellow colleague on the board, that can really be helpful there. And again, lessons from this proxy season show this continues to be a hot raw topic. It's something that investors actually care about when it comes to voting on director reelection year in, year out.
That's great, Brian. Well, this has been sort of our top 5 best pieces of advice for lawyers who are advising new members to public company boards. I'm Jack Clabby, Clabby, and with me is Brian Soares, Soares. We're both at Carlton Fields. Brian handles M&A work, corporate governance work, and disclosures work from a transaction side. And I work on investigations and litigation, corporate governance, and securities work. We're both at Carlton Fields. So one last plug for the American Bar Association's fantastic publication, the Corporate Director's Guidebook. That's from the ABA's Corporate Laws Committee, but I keep that at or near my desk at any given time in paper form. But thanks for joining us on Sound Advice, and we'll see you next time.